Leveraging your intellectual property, intro to licensing. If that's not the session you were looking for, you won't hurt our feelings. But if it is, welcome. Some of our intro slides here. This is part of the designer track of Denver Startup Week. We have been part of the designer track for many, many years, and we are grateful to the hardworking volunteers who put on Denver Startup Week, as well as their very hardworking sponsors. Thank you to them, particularly the Public Works and Battery 621 that have sponsored this track. More sponsors. Thank you, thank you, thank you, thank you. You guys are going to see these slides so much over the next 5 days. I am not Dave Ratner with Creative Law Network, who you all came to hear and listen to, and who is amazing and will be providing so much helpful information about protecting and licensing your intellectual property. But Dave and I get to work together through a program we run at CBCA called Colorado Attorneys for the Arts. And so I just wanted to give a quick commercial for CAFTA, Colorado Attorneys for the Arts. It is a legal referral service dedicated to the creative industries. So that includes artists and performers, filmmakers, authors, but also graphic designers, people who work in creative technology. We are here to connect you to legal resources like free trainings like today, free, 20-minute consultations, recorded webinars, but the core of our service is actually a referral service to connect you one-on-one with an attorney for actual representation. So after hearing Dave's wonderful presentation, if you're like, ooh, I really should have an attorney review that contractor agreement, my licensing agreement, register the trademark for my creative business, any number of legal matters that are directly related to your creative work, we are here to help connect you to those resources. It is a statewide program. There's our website up there, and I think that's all I'll share. So our speaker for this session is Dave Ratner with the Creative Law Network, and here to answer all of your questions and share information about licensing. This screen here is not huge, so this is also a great time if you want to move closer to be able to see the screen. This is a good time to do that while I pass the mic.
Thank you, Meredith. No, I haven't done anything yet. So thank you, Meredith. That's awesome. Appreciate it. And yeah, we can't control this. The slides are not entirely essential, but would definitely welcome you moving a little bit closer if you'd like. And I'll also make the slides available to anyone who wants them after we're done. So obviously, we're here to talk about licensing, and ultimately, I am here for you. So if you have a question, please ask it, because the more questions you ask, the more relevant this content is for you and your questions. Obviously, we have a lot of different folks at Startup Week in a lot of different areas of work. And this presentation is meant to apply to a lot of different areas of industry, but I don't know all of you, so I can't really guess. I certainly can speak from my perspective. So I'm an attorney, obviously. I run a law firm called Creative Law Network. We basically provide legal services to creative people and businesses. So what does that mean? It means we work with artists of all shapes and sizes, not just traditional visual art or music, film, television. We do all of that, but we work with all sorts of entrepreneurs who have creative ideas, who are trying to do maybe something old in a new way, maybe something entirely new. And a lot of what we're doing is we're helping people form businesses. We're doing a lot of intellectual property protection, and we're also doing intellectual property licensing. So that is what we are here to talk about today and to get through in hopefully about an hour. My background real quick, I refer to myself as a recovering band manager. I started in the music industry many, many years ago. Was on the road with bands. I can drive a 43-foot bus. I have sold all sorts of merchandise and have managed all sorts of bands, and realized that managing artists, or when I was managing artists, I realized all my artists need a lawyer. So went to law school and quickly realized that the legal concepts that we use in the arts, and for a lot of folks that are here, probably here on the designer track, apply to all sorts of businesses and especially startups. Because a startup is usually an idea. We've got something we want to bring to the world, and the same concepts, legal concepts, are going to apply to, well, to everybody in this room for the most part. And so what we're talking about today is intellectual property, or what we call IP, because that's what we're going to talk about licensing. And this presentation will kind of be in the format of how do we do a licensing agreement? Because if we are licensing IP, there's going to be an agreement for that licensing arrangement. Okay, and so IP is basically, it's intellectual property, so it is property, it's something you own, but something you can't touch, right? And so that basically means that you can, when I say own it, like you can own a chair or a car or a house or a phone. We own this thing, and in the same way I can sell my car to somebody else or I can rent it to somebody else. With intellectual property, it's the same thing. I own this thing, I can sell it, I can rent it, license it, lease it. I just can't touch it. And so we have four main different types of intellectual property. We have copyrights, trademarks, patents, and trade secrets. I'll go through these briefly so we have some context, but this is not IP 101, we'll do that another time. But certainly my guess is each of you have some connection to multiple pieces of IP, maybe multiple types of IP. So first we can talk about copyrights. Copyright is what we use to protect creative works. So we say that copyright is something that is an original work that is fixed in some way. The law says it has to be fixed in a tangible medium of expression, so written down, but that also can be captured in data in ones and zeros. So copyright protects literary works, musical works, dramatic works, pantomimes, choreographic works, pictorial, graphic, sculptural works, motion pictures and videos, and architectural works. Right? So copyright is in this creative realm, what we think of as the arts, what we think of as the creative world. And so copyright's going to protect when we paint a painting, when we compose a piece of music, when we take a video, that's all protected by copyright. So next type of IP we can talk about are trademarks. Trademark, the law says, is any word, name, symbol, or device that identifies the source of a product or service. What does that mean? That sounds like legal mumbo jumbo, right? What that means is it's how we identify what we're buying. Okay, when you go into the store, you see a label, you see something on the shelf, that is a trademark. You see the brand name and you know what you're buying. Same thing, you go to buy a car, you know what that brand represents. So we think about trademark, think of brand names, product names, logos, taglines. That's what trademark is about. And one of the kind of confusing things about trademark can be that one company can have a number of different trademarks. Actually, I can look at Denver Startup Week right here. So this says Denver Startup Week. Those words are a trademark. Then we've got this cool kind of mountain background with the skyline in it. That logo is a trademark. Then we combine this right here, although I know it's very small and you can't see it, but you're going to see it all week. The mountains with the words are yet another trademark. So trademarks are everywhere. And one of the things, from my perspective, that's cool, which things that are cool to lawyers are probably not cool to most of you, every business has a trademark. So you're going to name your business, that's a trademark. You come up with a design that signifies your brand or your product, that's a trademark. And one of the kind of purposes of this conversation or presentation is so we can identify the intellectual property we have, because it has value, and then we can protect it and know how we can use it. So just some examples, and again, the screen is way too small, but this is about 25 different trademarks, everything from the Apple logo to the McDonald's M to the Mercedes-Benz logo or the Nike swoosh are all logos. Those are all trademarks, but so is the word Honda or the word Coca-Cola. These are all trademarks. So again, putting it in context here, If you own a trademark, you may let someone else use it. That means you're going to license your trademark to them. If you need to use someone else's, let's say, we've got Intel. So let's say you're creating software that's going to, or you're creating hardware that's going to use Intel. You need the rights to use their trademark. You're going to license their trademark from them. So that's a quick 101 on trademarks. Last one being patents. Patents protects inventions and discoveries. Most of you have probably heard of this before. There are actually 3 different types of patents. One is a utility patent, which is a new and useful process, machine, article of manufacture, or composition of matter. So this is a utility patent is what we normally think about for an invention. We can also have a design patent, which is an ornamental design for something we manufacture, and there are actually also plant patents if you design a new plant. Basically, patents have to be novel and non-obvious. I don't want to, again, we're not going to do a patent lesson. I just want to make sure we're covering the types of IP. Trade secrets, we're not going to talk about licensing. Trade secrets are, well, what they sound like. They are secrets, but they cannot be registered. You're going to keep them very close to the vest. They're not going to be shared outside of the company normally, so we're not usually licensing them as much. Easy example of a trade secret is your contact list, your customer list. But the recipe for Coca-Cola is also a trade secret. Very well protected trade secret. Yes, ma'am.
So if you end up reselling your contact list data,
Mhm.
is that under a license?
If you end up selling your contact list, so selling it can be, well, if it's selling it, then it's a sale. If you're letting someone else use it, it's going to be a license. And certainly can be, yeah, absolutely can be licensed or sold. And thank you for the question. So basically, when we're talking about IP, one of the most basic things, yeah,
I'm sorry,
please.
just where would software or algorithm within software fall?
So software, where it falls in IP, will depend on a few different things. Software can be protected by copyright because the code can be protected. It's a creative work, you typed out the code. If it is new, novel, and non-obvious, it can be protected by patent as well. Yeah. And obviously, yes, software licensing is a very big thing. Software licenses are very long documents that we get, that as lawyers we get to read and draft, whether we like it or not. So one thing about IP is we want to think about who owns the IP. And generally, whoever creates a piece of IP is going to be the owner. Okay, the exception is if you create IP as an employer for your, as an employee for your employer, oftentimes the employer will own that IP. So very relevant if you're thinking, well, I have my day job, and my day job is to code software. Right, well, generally, the company you work for is going to own the software you create, but if your day job is, you're a ski instructor and you code at night or you code on your days off, well, certainly the ski company doesn't own the code that you create outside of your scope of employment. One of the things that's also generally applicable in all areas of IP is that the owner of the IP has a set of exclusive rights. When I say exclusive, that means the owner is the only person allowed to use these rights. This may sound kind of intuitive. You create something, you're the one allowed to use it, right? So if you create some software, you're the one allowed to publish it, put it out in the world. If you design, create a graphic design, you're the one allowed to make copies of it. You're the one allowed to post it on the internet. You're the one allowed to let other people use it or not. And so these exclusive rights are generally the rights to reproduce the IP, to distribute the IP, and then to utilize it in some way. So when we're talking about art, it's often to display it or to perform the art if it's something theatrical. And like I said, with more design stuff, it's often more about how we're utilizing it in the business world. But this is very important in the context of licensing because if you own a piece of IP and you want someone else to use it, well, that is going to be a license. So I kind of think about this as problem and solution. So the problem, let's say the problem is we own a piece of IP, we want to let someone else use it, but we want to retain ownership of it. So we're not going to sell it. We're going to continue to own it, but let someone else use it. Well, we're going to license it from them. Flip that on its head. Let's say we want to use someone else's IP. Well, how can we use it without buying it outright, which is normally quite expensive? We can license it from them. So the license is the solution to this problem of the transfer of IP. Like I said, IP is property. It can be bought and sold, but a lot of times we're just going to rent it. We're going to lease it, and that's what a license is, essentially. Any questions before I move on into the good stuff? Yes, ma'am. If you're the owner of the company and you create the IP, should you own it or the company own it? Obviously, every situation is different. And for this entire day, I am not providing legal advice. I am not your lawyer. Awesome. So yes, here's the thing. It really does depend. Generally, when we're doing something in the context of a business, we're going to let the business own it. And there's other liability issues that I can, again, a whole other presentation, but oftentimes in the context of, however, sometimes I have people start a business, but they're like, yeah, but this thing is mine. Like, I can, this is my thing, and you can create it, and you can license it to your business. You and your business are separate entities. So, not a clear answer on that one in all situations. Ownership can be shared. IP can be owned by multiple people. Mm-hmm. If you're a consultant brought in to create something, it's going to depend on the terms of your consulting agreement, really. I mean, because ultimately there's a lot of different situations. So, but what we're going to talk about is having that agreement in writing is very important. If you're a consultant, if you're working for another company, important to have that in writing. Similarly, license agreements should be in writing. For those of you in the back, that's what this says. Licenses should be in writing. Because verbal contracts are very hard to enforce, right? It very quickly devolves, when we have arguments about verbal contracts, it very quickly devolves into a he said, she said, and the only person who wins are the lawyers, because we just fight about it and make money, and you don't want that, I promise you. But a license agreement is a contract, okay? So it's an agreement between two parties, and a contract is really just, it's a legally enforceable agreement. Contracts certainly have a lot of legalese in them, right? They can be very intimidating documents, but they don't have to be. And that's one of the I'm going to talk a lot about contract terms in the next 45 minutes, but ultimately, you don't have to use a lot of legalese to have an enforceable contract. When we say a contract is, when in law school, what you learn in your contracts class, don't go to law school, I'm going to give it to you here, is a contract requires offer, acceptance, and consideration. That means is one party makes an offer to the other party accepts the offer, there's something of value, consideration is exchanged. So a contract can be very simple, okay? It's really just a promise or a set of promises, and what we want is to make sure that both parties, everything that is part of that agreement is in the contract. Nothing is left out. And that's one of the things I'm going to talk to you a lot about today, is just making sure we include all of the details. It doesn't have to be in legalese, it just has to be in there. Okay, so a law partner I used to work with told me, and this is great, a contract tells a story. Rather, it's great for me because I write contracts. There we go. That a contract tells a story. So it's going to say, who are the parties? What is being licensed? Where can it be used? When can it be used? Why are we granting this license? How is payment made? All the things that you would just think about that go into a story. One thing I will point out, as we're talking about licensing, there are usually two parties. The party that owns the IP and the party that is licensing the IP. So the party that owns the IP is the licensor. The party licensing is the licensee. So I own the IP, I'm the licensor, I'm giving you a license, you're the licensee. I'll keep it as little legal as possible, but that will make our conversation easier today. So, contract best practices, okay? A contract should be detailed, a contract should be explicit, and it should include everything even if it seems obvious to you. Over-explain things in contracts because the person reading it needs to understand what the deal was. People come to me all the time and say, well, we know the deal. We're cool. We got it all down. We don't need a fancy contract. I said, yeah, you do, but when you go fight about it, and hopefully none of you ever do, have to go to court, who's going to read the contract? The judge. Does the judge know the deal? No. The only way he will know the deal is if you put it in the contract. So don't assume anything is understood. Make sure all the deal points are in the agreement. The key points, again, it's kind of telling the story of what each party is going to do, when it's going to be done, what's going to be delivered, when it's going to be delivered, what's going to be paid, when it's going to be paid. And so you know, where this comes from is because in my world, I see when things go wrong, right? People call me when there's a dispute. No client has ever called me and said, hey, everything went great today. Not my job, right? So I think about contracts in terms of let's think about what could go wrong and do our best to prevent something going wrong, because what do people often argue about? Getting paid. So I make sure the payment terms are always super clear, what and when is getting paid. Another problem, they didn't give me what they promised me. Let's be super clear, what you're going to get, when you're going to get it. So those are the details we always want to have in a contract. So let's dig into some, yes, sir.
This is not directly related to licensing, but maybe a little bit into what you're talking about. If you're a startup and two people, partnership, right, and you have different tasks, I guess, how do I word this? Like, is there guidance on if one person does more development work and the other person does like more sales and other stuff? Is there guidance out there in the organization on ways to structure contracts on I mean, clear, like, in a perfect world, 50-50 split.
Sure, so it's like a partnership agreement.
Right.
Yeah, yeah. So
Guidance on ways to structure those different types of tasks and how it's fair, because everybody thinks they're doing the most work.
of course. No, I mean, anytime you're starting a business, having that agreement with the people you're starting the business with or bringing into the business is really important. And yes, it's laying out, it's kind of the same things. It's laying out who's going to do what, when they're going to do it, what they're going to get paid for doing it, right? So it's including all those details. So same principles apply, right? So everything I've been talking about is contracts in general. We're talking about license agreements specifically. That's what's coming next here. So the thing we're going to talk about at the beginning usually is what is being licensed. And again, this may seem obvious. It's like, well, that's what this whole contract is about. It must be clearly defined, right? Because let's say you're licensing some software. Well, are you licensing this version or every subsequent out? If you're licensing a design, right, a graphic design, okay? Are you licensing just the black and white version or the color version as well? It may seem obvious, but we want to make sure it's in writing. So we want to describe exactly what's being licensed. And you can reference other materials. I mean, for example, copyrights have copyright registration numbers. So do patents. We could say it's registered under this number. We can attach an example, pictures, whatever it is that makes it very clear exactly what is being licensed. And if necessary, what's not being licensed. If you are the licensor, if you are the person granting the license, you own the IP, you may say, you get this, but not that. And that's important as well. We want to be super clear so we're avoiding any conflicts in the future. Yeah?
On the context of licensing, do you need to turn in the original works or just a JPEG? Like, how is the format?
So we'll talk about, the question about whether you need to turn in or provide an original, whether you can provide just copies, we'll talk about that. It does depend on what's being licensed, right? How many different versions there are. And again, there isn't it always has to be this way. It is whatever we agree on, let's make sure we write it down. It's basically what I would say. So basically, yeah, we just want to make sure we're describing the IP that we are licensing. I'd say sometimes the most important thing in a license agreement is what rights are being granted. Okay, so you own a graphic design. You're a graphic designer, you designed this thing, and you're letting this other company use it. Okay? Well, we want to be very detailed about what they can and cannot do with that design. It may be they can put that design on their product, and that is it. It may be they can put that design on their product, in their advertising, on billboards, on their website. Maybe it's everywhere. Maybe it's an unlimited license. But we really need to know, because that's the purpose of this agreement, is to detail that. I very frequently have someone say, well, we're granting a license, but we really need those details about where, when, who, what, why, what I was talking about earlier. One other legal language thing, we often say that the licensee is allowed to exploit the IP. That does not have a negative connotation. That's just a legal term that means use the IP. So we can just say that the licensee is allowed to exploit the licensor's intellectual property. That's basically what we're talking about in a license. So let's talk about that exploitation, that use, because we want to be very detailed about where and how the IP can be utilized. So things about like in what format. You're just asking a JPEG, or does it have to be the native file? Do we have to give them the file that can be manipulated, or can we just give them the final? We have to put that in the contract so that we know. In what media can it be used? So again, can it be used on physical product? Can it also be used online? If we're talking about it can be used online, can it be used just on the website? Or can it be used in socials and in advertisements and in videos, right? And these are things you basically want to think about all the possibilities and then try and address those possibilities in the contract. And we can use language that doesn't have to identify every single thing, or line by line. We have general language that can specify these things without a super long list of things. Yeah.
If you have a product that you use that you come up with, you have a utility patent, and want to go and license it, does that also include like printed materials? So if you have how to build something with utility patent, and they want to use that and say, yeah, we use it this way and it's built this way in the document in the literature, is that also?
So if you're licensing a patent where the documentation comes with it, is part of the license? Yeah, generally it will be, but again, it's up to the negotiation of the parties. And that is most of these things, right? It's that the parties get to decide and then we put it in writing, but it's a great example of something you want to make sure to put in writing, right? What do they get? What comes along with it, okay? It also may be, for the utility patent, it may be you can use this, but only in this product category and not in that product category, right? So there are all these lines we can draw, and if I could give this presentation just to graphic designers, I could be much more specific, or just to inventors, I could be much more specific, but then I wouldn't have so many of you beautiful people here. So we're just going to be broad and try and include it all. But another thing is who else can use it, right? When we grant a license to a licensee, we want to be very specific about who can use it. Either that company, does that company have subsidiaries? Are there people within the company or departments, things like that? Just think about, if you are the licensor, it's helpful to think about what would make me mad, right? What's not part of this deal? What do I want to not happen? And we put that in the agreement as well. So we want to include the limitations. We want to include what is okay as well as what's not okay. Because again, in my world, it's the what's not okay that ends up causing the problems. Ideally, with all contracts, we write the contract, we sign the contract, we never look at it again, which is very frustrating, because then why'd you pay this lawyer all this money to draft this contract? The reason is we look at the contract again when something goes wrong. It's insurance, it's protection. And certainly, if you're the licensor, it's protection for your IP. If you're the licensee, it's protection for what you're spending because generally we're going to pay for a license. So we want to make sure we're getting what we bargained for, essentially. So other terms that we're going to include in a license agreement are the territory, so where can this IP be used, and the term, how long can it be used. So the territory, we often think of that as the geographic territory, or I do anyway. So it means you can only use it in Colorado, you can only use it in the US, or you can use it worldwide. But certainly, so many of the things we're going to be licensing are digital, that the territory can also mean what media, like I said, can it be used on socials or just on the company website? Can it be printed? And maybe we say for some IP we're licensing only a certain number of print copies. You can make 1,000 copies, but no more, then you have to come back to me to ask for more. So we want to make sure we limit where the IP can be used, both geographically and what medias or formats it can be used in. And then we also want to talk about the term. The term is the length of the license, the length of this permission that we're granting. And the term is usually a set period of time, right? So you can use it from today until the end of next year, or for 1 year, or for 5 years. Sometimes the term is forever, what we call a perpetual license. And what can also, it can also be, the license can be for the life of the IP. One of the things about intellectual property protection is that it lasts for a set amount of time. So for example, a copyright, if I write a poem today or I paint a painting today, that copyright exists for 70 years after my death. That's a pretty long time. Patents are much shorter, 20 years. Trademarks can be renewed every 5 or 10 years. So the life of the intellectual property protection may affect the term or the length of the license. So other kind of important things to make sure we're including. Another thing we want to include is, what are we getting? Or what's going to be handed over to us when we license this IP? Okay, so we call this the deliverables. Deliverables meaning what the licensor is delivering to the licensee. And going back to the question up here, which was, is it a JPEG or is it a native file, more of a adjustable file, something we can edit, an editable file? We want to make sure that's specific and explicit. And we also want to talk about when those deliverables will be delivered. Okay, so this frequently happens where we say, okay, we're hiring you to create this IP, we're going to license it from you. Well, make sure that it's going to get done according to the timeline that's going to work for the business, because the license doesn't matter very much if we don't get the deliverables in a timely fashion. Same thing with the format. Does it come with printed materials or with the documentation, right? Is documentation included? And the idea being, we want to make sure, I guess all of this is that we're getting what we bargained for, that what we think we're going to actually receive from the licensor, or if we are in the licensee's position, that what we think we're going to receive from the licensor is actually what we receive. And if you are the licensor, you want to make sure that you have these things to deliver and that these are the things you want to deliver. There may be, perhaps there's protections on there. There may be some sort of digital protections on these files. Whatever it is, we just want to make sure we're detailing that in the agreement. Because everything we're talking about is everything that goes into this licensing agreement. And I know some of it may apply more to some of you than others. We try and make it all fit. Another thing that may happen is there may be some services that are part of the deliverables. Perhaps you're licensing this IP, and along with the actual IP comes some sort of support. This certainly happens with software, right? But it also may happen it could happen with a graphic design where we're going to make new iterations of it. Right, maybe it has a year on it, we have to change the year. Maybe there's a color scheme we change every year. Whatever it is, so if I'm licensing some graphics for my company, and I know I'm going to need that update, maybe it's the logo and licensing for my letterhead and all that sort of stuff, and it has my address in it. Well, if I change my address, Do I have to go pay for those changes, or are those services included? So again, we're just thinking about all the things that might happen down the road and trying to prepare for it so that when they happen, the contract tells us what to do. I think one of the most important things is payment, usually important for both sides, oftentimes more for the licensor. And generally, in a licensing scenario, payment happens in one of two ways generally. Usually there's either a flat fee or some sort of royalty. So the flat fee is like a guarantee. It's a set amount of money we know we're going to transact. If it's a royalty, it's usually a percentage. It's something that's based on either sales or volume or some use of the IP. There are pros and cons to both of these. Certainly, if you are the licensor, a guarantee sounds kind of nice. You know you're getting a flat fee regardless of what happens. But maybe if you had done a royalty, you would have ended up with more if that product becomes very successful or if that use becomes very prolific. So sometimes we combine the flat fee and the royalty in the compensation arrangement. In other words, there is an upfront amount and then there's a royalty paid in addition or to recoup that flat fee. So there's a lot of different ways this can happen. So there's something called, sometimes we use what's called an advance. Advance is we're advancing you a certain amount of money. So let's say the royalty is $1 per unit, okay? And whatever the IP is being used on units, it's $1 per unit, that's your royalty, but we're gonna give you a $5,000 advance. That means is you're guaranteed $5,000. Here it is, you get $5,000 whether I sell one or I sell a million. And since I gave you a $5,000 advance, the first 5,000 units have already been paid. I advanced you the royalty on the first 5,000 units. Starting with unit 5,001, you will get $1 for each unit after that. So a number of different ways this can be structured. And again, really important that it be specific. The royalty arrangement, I just use the per unit or per sale example. A royalty is often also, or can be, a percentage. So it's a percentage of sales. So I license my IP to you, you're selling it in your product or with your service, and based on the amount of money you make with my IP, you're gonna pay me a percentage of that money. Now, that percentage can be really lucrative for the licensor, for the person owning the IP. If that product is successful, you're kind of taking a risk on the person who's selling it probably, because if they're not successful, then you don't get a lot of money. But one of the important things about a percentage royalty is we have to be very specific on what it's a percentage of. The most common distinction is it a percentage of net or is it a percentage of gross? Right? Gross is every dollar you make, I get a percentage. Net is after you recoup all your expenses, I get a percentage of the profits, essentially. The calculation of net can be really complicated. It can just be gross minus taxes. Super simple example of how to calculate net royalties. It can also be gross minus this. It can be pages to define what net is. And I kind of see a number of you looking at me a little cross-eyed like this is a little crazy, and but this is what gets negotiated. This is what we have to get into, usually to make ideally to make a deal that is good for both sides, but also for the contract to reflect that deal so we know exactly what the deal is, right? So we don't have to worry about calculating it later. We agreed this is how we calculate it. When we are doing a compensation arrangement that includes some sort of royalty, some sort of calculation, we're usually, as the person being paid, you're usually going to want some sort of accounting, right? There's a statement that says, I sold this many. Here's your percentage. Here's what you get paid. If you just get a check with no accounting, how do you know what that money's for and whether you're getting paid the right amount? Ideally, you are getting paid the right amount. If not, that's when I get a phone call, right? But the accounting, are we getting paid monthly? Are we getting paid quarterly? Are we getting paid annually? Again, these are things that people just say, oh, you're going to pay me 5%. How often? How do we calculate it? These are the things that go in to the contract.
I would think that there's industry specifics, right? That an entrepreneur would come to you and say, this is how a licensing agreement typically takes place. But I'm curious how many actually don't know that, and then in your role, you take and kind of serve as a consultant to say, have you considered net or gross? Have you considered these sort of line items, right? So what does that dialogue look like?
So, great question. Thanks for asking about how we come up with this between the attorney and the client. And it really does vary. Certainly, we have clients, we have entrepreneurs, we have businesses that come to us and say, this is exactly what we want, right? But a lawyer's job is to think of all the things that the client didn't come with. So that when the client, yes, because I've had clients say to me, it's 5%. Have a nice day. And this is where I come in and say, is it gross or net? How do we calculate net? How often are you getting paid? Now, Dave, now I have a presentation for you, right? Because these, again, this presentation is based on my experience, right? What my experience in coming up with these agreements has been over the years, and you pretty much just hit it, is that these are the questions we have to ask. We want the contract to answer all of those questions. And it is, by the way, it is not incumbent on you if you are going to hire an attorney. It is not your job to give them all the answers. You're paying them because they have well, ideally, they have a knowledge set and they have that experience. And we can certainly talk all about how to choose an attorney, but ideally, it's someone who knows your business and has done it before, right? You don't want them learning on your watch. And if they're not asking a lot of questions, maybe we ask them some questions like, hey, have you done this before, right? Because we want to make sure we have that basis for experience. Of course, thanks for asking. One other thing about when we're getting paid a royalty or getting paid at all, we may have as the licensee, as the person getting paid, as the licensor, as the person getting paid, we may want to have an audit provision. We do want to have an audit provision because what an audit provision does, it lets us see their books. Okay, so if I'm supposed to get paid $1 per unit and they say, here's your check, it was $32 last month, 32 units. And I'm like, man, I've seen 32 units when I walked one block. You're selling way more than that. I need to be able, and they say, no, that's all I got, that's all you sold, all I sold. We're going to need to audit their books. Hopefully we don't have to audit their books, but we want to have the right to see what's actually going on to make sure we're actually getting paid what we're meant to be paid. Yeah, it's a term in the contract. There's an audit provision. So, and I think in contract, there is a paragraph that will say, so it doesn't just, it's a great example actually, because it doesn't just say, we get to audit, right? It's going to say, we get to audit with 30 days notice at your place of business or wherever you keep the books. And they're going to say, okay, fine, you can't audit more than once per year. You can't audit more than once per statement. So this is the negotiation that happens, and it results in an audit provision that hopefully isn't too long, but it includes all those details. So yeah, I mean, pretty much everything I'm saying is in a paragraph in a contract, in a license agreement. Exactly. Yeah.
On the negotiation for the percentage, the royalty, gross net or wholesale, can you request like sort of an audit if they say like if they throw you a really low percentage and then we want to understand their sales track, can you ask that like audit on the negotiation of previous work?
So you're saying when you're negotiating the percentage, can you ask for a history or something in that negotiation? Sure, absolutely. And I'll try and repeat the question, thank you. So that yes, I mean, that's all part of that negotiation. There aren't laws about this, right? It's like, it's part of the relationship, it's part of that back and forth, and it's going to vary a lot just based on the situation.
If you're a small entrepreneur, you're dealing with possibly a large say like Lowe's or whatever, are they going to really push back on the auditing? Because it's a little part of their big business.
Sure, so if you are working, it doesn't, big or small, the company being audited may say, hey, you can't see my books. The audit is limited to the books that are relevant to your license. And it'll, by the way, that is the language we use, right? The books and records related to this subject matter, or however we're defining it. So yes, and if you are the one who is having your books, or are the license, the person in the contract whose books will be audited, you're going to make sure that is in the contract. And you're going to be the same one saying only once per year, only once per statement, and so on. So those protections can be added, for sure. Absolutely. I love this because you're all asking questions about the money. So you're thinking, this is exactly right. These are the things we fight about, is how we get paid and when we get paid. Another thing that is actually compensation in a way is credit, right? Because we oftentimes, as a creator or licensor, will want to receive credit for what they've done or what's being used. So that is another kind of piece, another provision in the agreement, is that is the licensor going to be credited? And we want to make sure, again, that we're detailed about when and where that credit happens. I mean, if you think about a movie, right? At the end of the movie, there's a long list of credits. Well, all those credits have been negotiated because people want their name in a certain place, in a certain font size. Okay, and but it's the same thing if you're licensing your IP for use in or with a product, in or with a service. Do you want to get credit for it? And if so, how do you want your credit to look? Where is it going to appear? For intellectual property, we have insignias, we have symbols. The C in a circle is the copyright symbol. The R in the circle means we have a registered trademark. A patent has a patent number, so that may be part of it. You may say, yes, you must credit me and you must include the patent number. Or maybe you just say, you just have to include the patent number. I don't need my name on there just so everybody knows that it's patented. So that may be part of it, but we may get into where does the credit appear? Because for going back to the movie example, when you see an advertisement for the movie, you don't see all those credits, right? But when you see the trailer, you do see the director and the writer. So all that stuff is negotiated about where and how credit appears. And we also should put in there what happens if the credit isn't given, right? What's the remedy for that? How do we repair that situation? There are times when, if they're using your personal name, like we're going to credit Joe Smith, you have to give them the rights to use your name. Are they going to use your picture? Are they going to use your bio? Right? If so, these are all things that you own and have control over. So you want to be detailed about what credit is given, what rights might be necessary to give that credit. There's a part of every contract called representations and warranties. There's a lot of words on this slide for those of you in the back, but that's what it says at the top. Representations and warranties. Representations and warranties are basically promises. I am representing to you, I am giving you a warranty, I am warranting to you that these things are true. And so they're really important. It's very important for a licensee to get certain promises from the licensor. Most importantly, we want the licensor to promise they actually own this thing, which may sound kind of crazy, but is actually not that crazy. IP can be very complicated, and the ownership or disposition of that IP is sometimes not so straightforward. And one of the ways that we can get in trouble is if the person who says, here's my IP, I'm licensing it to you, but they actually don't have clear rights to that IP, then you can get in trouble because you're using IP that they didn't have the rights to, which means you don't have the rights to them. Sorry, it's a bit of a chain of logic there. But basically, the licensor should generally promise that they own the IP or that they control it. They might have licensed it from someone else. And that they have these rights to give to you. Okay, so as we said, we can divvy up rights lots of different ways. And so we want to make sure that if they're licensing you this IP to put on physical product worldwide, that they have the worldwide rights to use this IP on physical product. Also, we want them to promise that this IP doesn't infringe someone else's IP. Because if it does, then you're going to get in trouble for using it because you're infringing as well. So if, for example, someone creates a graphic design, okay? But their graphic design is actually identical to somebody else's. They stole it. Well, then the person they stole it from can come after you for using it. So we want them to promise that they have all these rights, that the rights aren't infringing. There's also some mutual promises that both sides will make, things that, again, sound kind of simple, but that they have the person signing this has the power to sign the agreement, because if it is with a big company, big multinational, it can't be the mail clerk that's signing, right? It has to be someone with the power to bind the company to a legal contract. And often we'll also make them promise this contract doesn't violate another contract. If this is an exclusive license, if they're saying, hey, I promise you're the only one who's getting to use it, we don't want to then go find out they granted the rights to someone else. So the fact that this contract doesn't violate another contract seems kind of obvious, still worth having in the agreement. On the representations and warranties, there's something called indemnification. Indemnification is one of the most complicated concepts that I've run into in contract law. So I'm going to try and make it simple. But basically what indemnification is, it's saying that if one party does something wrong and the other party gets in trouble, the first party pays for the second party's defense. Okay, so in the example, if we have a licensor that says, I own all the rights to this and I'm granting it to you, but they didn't own the rights, and then you get in trouble, they pay for your defense. It's basically what indemnification is, and it's really important in these licensing scenarios because we want to make sure, we may or may not know, as a licensee, you may or may not know very much about your licensor. You may or may not know very much about the IP that you're licensing. So this indemnification is really good protection so that if something goes wrong, if you get in trouble, that they will have your back, that they hold you harmless is what, and we often say, or we do say, one party will indemnify and hold harmless the other party, and that's really what it means. We will make sure you are not harmed by what we do. I actually did include some legal language in here straight out of a contract, which again, I know many of you can't see, but I will go through it very quickly. I mean, because it's an example of how contracts often include a lot of mumbo jumbo that makes it hard to read the contract. So this clause says, each party indemnifies and holds harmless the other party, its officers, directors, employees, contractors, agents, successors, and assigns from and against any and all claims, liabilities, losses, damages, judgments, costs, and expenses, including reasonable attorney's fees arising from or related to the indemnifying party's breach of this agreement, misdeed, mistake, or error. Why? Right? But the thing is, and this is, again, I'm sorry for those of you in the back, but one of the things I just like to use to help explain a little trick is when we have really complicated language, a lot of times we can simplify it by just looking at the important words. All that paragraph said was, each party holds harmless the other party from all claims related to the indemnifying party's breach. That's all that said. So, little contract draft or contract reading tip, when you're handed a contract that seems super confusing, a lot of times we can use this trick to get through what can be confusing. Question in the back somewhere? No? Okay, we'll keep on. We'll keep rolling. So one other thing in our agreement is going to be, in our licensing agreement, is going to be remedies. Remedies are what happens if one party breaches the agreement. What options does the other party have? Because obviously you think like, oh, well, if someone breaches, I can terminate the agreement. Well, you may not want to terminate the agreement. You may want to have other options. Well, one such option is something called injunctive relief. It's often referred to as equitable relief. Injunctive relief is getting an injunction, right? Getting a court to order someone to do something or order someone to stop doing something. And this can be a really valuable tool when someone else breaches an agreement. However, if you are a licensee, if you have licensed some IP from someone, you don't want there to be injunctive relief. You don't want them to stop you from using the IP that you licensed. Because people use courts and breaches and things like this to, unfortunately, for nefarious reasons sometimes. And so it is one of these things when you're reading through a contract and you see injunctive relief in there or equitable relief in there, this is what it means, and this is why it can be good or bad for you, depending on which side that you're on. So sometimes if I'm representing the licensee, I'm going to say they cannot get injunctive relief. They cannot get a court to stop us. They can sue us if they want to, but it doesn't include an injunction. You have to speak really loudly. After the expiration? Right, so if the licensee continues to use the IP after the contract expires, right. So we'll often have a term in there. Well, one thing is we'll have something in there that says when this contract expires, you must stop using the IP, right? And there's many different ways we say that depending on what the IP is and what context it's being used in. We're going to have remedies for that. For example, if it's a product that's being sold, you may get all those products back, or they have to be destroyed, things like that. So it's a great thought. It's something we certainly want to protect for. It's just going to be really dependent on the details of the situation. Yeah, we want to have it, and I'm sorry, there's a fan up here, which is why it's just hard for me to hear. Yes, we do want to have it written out in some way. It's situation dependent. Ultimately, here's the thing. With any contract, when a contract is breached, the non-breaching party's ultimate remedy is to go to court. And by the way, saying that there's no injunctive relief does not mean there's no relief. You basically can go to a court and collect damages. So most of the time that we go to court in business scenarios, we're going in saying, Judge, they breached the contract, we need to get paid. They damaged our business in some way. The remedy is usually money damages. The alternate remedy can be injunctive relief, where a judge can force a company to do something. But for the most part, to have a colorable claim in court, you have to prove you've been damaged in some way. And the most common way those damages are made up is through payment, is through money. So that is ultimately the tool that you have, is taking someone to court because they breached the contract. They're infringing your IP. Because ultimately, if the contract has expired, they no longer have rights to the IP. They are now infringing. You can have an action for infringement and for breach of contract. I could go on for another hour about that as well. But I want to get through just a couple more slides before we finish, and I'm happy to hang out for as long as possible to answer more questions. So let's see. Yeah, 2 more slides. That's all it'll take me. Sublicensing, okay, which means sublicensing is the licensee can grant to other licensees. Okay, we may or may not want this to happen, so we want to specifically say whether we do or do not want this to happen. There are lots of different scenarios where that can happen. Sometimes they make sense, sometimes they don't. But if we are the licensor, the only person we want to use it is this licensee, we say no sublicensing. The other way these rights can be transferred down the line is with what's called an assignment. An assignment is basically transferring the contract. So I license my IP to Company A. Company A says, I'm just going to transfer this contract over to Company B. Now you're licensing to Company B. Now, there's other ways a common way this happens is if Company A gets purchased by Company B, well, then it gets assigned to the purchaser. But we want to say, is that allowed? Do we require permission before you can assign it to a purchaser? So a lot of times it can be allowed. We just want to make sure the assignee, whoever is making the purchase, whoever is getting the contract, is going to be liable for all the obligations of the first party, of Company A. So just one more thing to think about that can happen here. And the very last thing, chronologically, is termination. How do we get out of a contract? If you ever look at a contract and there's nothing in there about what happens, how to get out of it, pay attention. Because oftentimes, again, we pull out that contract when something goes wrong. When something goes wrong, we may just want to get out of this deal. How do we terminate the contract? Can we terminate the contract? sometimes the only way we can terminate is if there's a breach or if someone declares bankruptcy. But what are those situations? And because generally, if you are the licensee, you will not want to allow for termination. Generally, you're going to say, I get these rights regardless of what happens. But if you're the licensor, you want to be able to get out. Well, if there is a termination, is there a refund of any sort? If we printed a whole bunch of product, can we still sell that product? Again, we want to think about the various ramifications of how this goes down. So, like I said, I literally can talk for days. I teach law school. I can talk for semesters about this stuff. And this is really just a primer, but I figure better to get a little bit than not at all. So I will also say that I have business cards up here for those of you who want to keep in touch, because ultimately, like I said, I was here for you, and I want to make sure I'm happy to hang out and answer questions for as long as you'd like. If you have to run to the next thing, grab a card, send me an email. I'm always happy to chat. But this is really, again, scratching the surface, but I hope that it's been useful, helpful, and interesting, and I very much appreciate all of you being here. So thank you very much.